exchange your knowledge and expertise in your professional field. The purpose of CPA Australia Discussion Group is to provide a forum for like-minded members to exchange information and share knowledge on topics of common professional interest. CPD hours can be claimed for discussion group session with appropriate professional content. We believe that our discussion group is here to support members, support professionals, support businesses, and support community, because we believe together we can make a difference. Just a few housekeeping. If you have any question, please raise them in the Q&A box, in the chat box, I mean. If we were unable to address all the questions during this webinar, we'll take them offline to the speaker. The webinar and all chat histories are being recorded, and subject to the consent of the speaker, we may publish the recording and relevant presentation material via our email system in the next few days. For anyone attending via telephone audio dial-in, if you can email us your name and phone number used to dial in, so we can record your attendance as well. So thank you for your support, and please let us know if you have any feedback via our email, which is members@citytaxation.com.au. Also, I would like to remind you that if you're on social media, please hashtag CP Australia, hashtag City Taxation, hashtag Together We Make a Difference, and share any information that you think relevant and will benefit other members. And also, most importantly, if you haven't followed our social media page, please follow City Taxation on Facebook, Twitter, LinkedIn, Instagram, and if you want to be part of our WeChat and WhatsApp group, you can contact Henry directly. So we are fortunate to have Richard Lane from Pozinski Robinson joining us tonight. Richard is the director of Pozinski Robinson with a focus on commercial and insolvency litigation. He enjoys an enviable reputation as a problem solver with over 25 years experience in Australia and the UK. Richard has a reputation for resolving litigation often involving complex financial structures and funding arrangements. He has a specialist knowledge of the areas of surety and trade credit insurance and the issues that can and do flow from such financial modelling. He is well known within the insolvency sphere and regularly presents at workshop and training session for ARITA. His insolvency experience extends to acting for and against liquidators, receivers, administrators, and trustees. Richard has worked on some high-profile cases involving Greensill, the Arium Group, Amerin, Lehman Brothers, and companies within the Alco Group in all courts of Australia. Before I hand it to Richard, Henry will give you a bit of an announcement of you can go to YouTube if you want to watch this live webinar as well. Henry?
Yeah, okay, thank you, Teddy. Obviously, we have 100 people limitations on our current meeting confirmation, these particular Zoom meetings. So if you are being dropped off and unable to rejoin these particular meetings, there is a YouTube live stream that is currently available. And if you attend that YouTube live stream, can you please screenshot your attendance so that we can verify and issue you the certificate for attendance. The certificate can be downloaded from our website directly after the event once we verify the attendance. That certificate obviously can be uploaded to CPA for your confirmations of the attendance. And going forward the next year, we might move our facility to Microsoft Teams, subject to the technical availability at the CPA office. And then we'll make further announcement at that point. Richard, back to you.
Okay, thanks, Teddy. Thanks, Henry. I'm going to talk to you today about trusts and the issues that arise in an insolvency. The genesis for this discussion and this seminar was a case called Amerind, which was the last time that the High Court was asked to look at trust legislation or trust statute, and its interlinking with insolvency, specifically the Corporations Act. So that was in 2019. I was involved in that decision. we took the case to the High Court. The opposition was the Commonwealth Government, and it was involved all the Secretary Generals as well of each state appearing and making representations simply because of the effect that it would have. So what I'm going to talk to you about today is, I'm going to try and map out where we're going. So I'm going to start off and give you a brief introduction to trusts. I'm sure you all know it. I'm sure you're all aware of them, but within the legal fraternity, within the Corporations Act, the Insolvency, there are specific elements of trusts that are important and have a knock-on effect, and it's those that I want to talk to you about. So I'm going to give you a brief introduction. I'm going to talk very briefly about the use of trusts, and then I'm going to break it down into two sections. I'm going to break it down to the first section where the trustee is a corporation and has been operating as a trust, so liquidating a corporate trustee. Now that has two impacts, which I'll come to later, which are what is trust property and what is company property, because that's important, an important distinction, which we'll come to as to what's going to be available for creditors. The second element that we'll then look at is what happens in a bankruptcy. Now this is probably I'm not going to say it's a more common area, but it's where we've got the professional insolvency practitioner having to deal with discretionary trusts, how they're going to break them, how they're going to get into the assets. Because I think there's a general thought that a discretionary trust will protect you fully. And I can tell you the insolvency practitioners that I act for, and Henry's one of them, they on a regular basis break into those trusts. And they've got various tools that they can use to do that. So I'm happy to take questions as we go along. I can't actually see the question box, but I'm sure Henry will let me know if I've got a question.
Yes.
So the first point then is, what is a trust? Well, the common misconception is that it's a contractual relationship. It isn't. When you track through where trusts dates back to, they date back over 200 years, and they were a implement, for want of a better word, that was created by the courts of chancery, the equity courts over in the UK, England and Wales. And what they do is they recognize that in certain circumstances, people and or entities will have obligations imposed upon them by virtue of a relationship. So when you really break it down to its very basic level, a trust is an arrangement which allows a person or a company to hold property or assets for the benefit of somebody else. The person holding the assets, a trustee, the party whose benefit it's held for are known as the beneficiaries. Now, it's important that you right at the outset understand that the property is held in one party's name for the benefit of somebody else. Now, the separation of the title and benefit means that trust law and trust legislation and the effects of the trust can be used in any number of ways. It can be used for asset protection, where you get the discretionary trust. You can have a fixed unit trust. You can have a bare trust. It can often be used in financial structures, where you get structural finance, where you want to actually separate and preserve the asset while still dealing with an income stream. So the trust as a tool has a lot of benefits and can be used in any number of ways. What is important though, whenever you're dealing with it and dealing with a trust, and the ways and the reason why it's of such benefit, the reason why people look at it as being an asset protection scheme, is this separation of legal and beneficial ownership. Any lawyers in the room will fully recognize when people talk about legal title and beneficial title of property. That's why you have two titles. So the legal ownership is in one name, but it's held for the benefit of others. And that's why in property transactions, you can have to distinguish between the legal title and the beneficial title. You can also see it when you've got shareholdings for companies, where the legal title could be in one person's or one entity's name, but they don't actually hold it beneficially, they hold it on trust. So what we have here is the arrangement whereby there's a separation of ownership and benefit. Now, it's not a contractual relationship. And I say that again, it's not a contractual relationship. Quite often, though, and what you will generally find is that there'll be a trust deed. And what that doesn't create the relationship. What it does is it determines the powers, the duties, and the obligations of the trustee. Now, those obligations can be controlled and are dictated to by the trust deed. In the more complex financial structures, what you might find is that the trust deed determines who gets what distribution and how it's to be distributed, when it's to be distributed, in what circumstances it's to be distributed, and how much is to be distributed to different entities. So by using a trust structure, you can create different grades of beneficiaries. So for lending, you could have first tier lenders, second tier lenders, or third tier lenders. And that's why the trust deed comes into it. So having now separated, and I hope understood the importance of the separation of title and benefit, we then need to look at the actual role of the trustee. And in this regard, I'm talking specifically about the corporate trustee. So this is where there's a corporate trustee who is trading as a Pty limited company, not on behalf of its shareholders, but on behalf of a trust. So what happens in those circumstances? What does it mean if there's a trading trust? Well, at the outset, it means that the trustee is personally, so the corporate entity is personally liable for the debts that are incurred. So even though it or she is trading as for the benefit of a trust, they are personally liable for any debts that are incurred in relation to that. But they do have two rights, and they're very old-fashioned rights. They're a right of indemnity, and that right of indemnity is supported by an equitable lien over the trust assets. So even though they're personally responsible for the debts, they do have a right of indemnity against the assets. Now, the equitable lien we'll come to shortly, but that's basically effectively a charge over the assets of the trust. It only arises, though, for debts that are incurred when the company or the individual is acting as trustee. So quite often what happens is you have a company that's trading in its own name, and it has that it's trading also as a trustee on behalf of some unit trust or some other trust. And when you go to court, when that company goes into liquidation, the first test that the court will apply is, was it actually acting as a trustee? Because simply because somebody says it acts as a trustee, it's not a contractual relationship. It's actually what is the relationship that exists, and that's what the court will look at. So when they're looking at that and they're trying to assess whether in certain circumstances a company has acted as a trustee or not, they will look at the surrounding circumstances. They'll look at all the facts and make a determination. Facts that they'll look at probably are going to be the ATO records. Is there a trust deed? Quite often there isn't. What do they put on bank applications? What do they say to third parties? What do their bank statements say? It's only once the court has accepted that corporation is acting as a trustee, that the trust legislation, and it's not really legislation, it's a trust law that's been handed down over the past 250 years, has an impact. So the important asset here, though, is the right of indemnity. So whenever a lawyer gets hold of his trust, he'll say, what about the right of indemnity? This is the first way in which the trustee can actually access assets of the trust. It's his only remedy, really, to get into the trust assets, but it does enable him to do so. So there are two types of rights of indemnity. There's recoupment and exoneration. Now, they are slightly different and they have different effects legally. Overall, though, they're the same. The right of recoupment is where the corporation may have assets of its own that aren't held on trust. They're held by the corporation for the benefit of the corporation. And if it has used those assets to pay down or pay debts of the trust, then it is entitled to recover that and seek reimbursement. Now, quite often that's an unusual set of circumstances. And it's unusual because with corporate trustees, they normally don't have assets outside the trust. They don't have any assets in their own name. It can happen, but it's unusual. The second position there is exoneration. The right of indemnity arising for exoneration. Now, this is where the debt hasn't been paid. So the company hasn't paid the debt, but it remains there. And in those circumstances, the trustee, the company, can look to the estate to discharge that liability. So it can use trust assets to discharge the liability. Now, that's the more usual position. So I'm going to do a quick summary here. The whole point of trusts is that it separates legal ownership from beneficial ownership. So legal title is one name, beneficial title, or the real benefit of that asset, is in another. It's subject, though, to this right of indemnity. So any costs that are being incurred by the trustee that relate to the trust have to be paid. Now, that's all well and good, but what's the point of a right of indemnity if you can't do anything about it and the assets have gone? So this was recognised by the courts. It's been recognised by the High Court in Australia. And the answer is that the trustee will have a lien over the trust assets. Now, that lien is for liabilities that are properly incurred. It's for those liabilities that are only liabilities associated with the trust. And that'll be important when we look at the next step, which is liquidation. So only those liabilities that relate to the trust that have been incurred on behalf of the trust are subject to the lien. Now, solicitors love words like lien because they're fairly broad and we can throw them out, throw in a bit of Latin, and everybody loves it. We all look fantastic. Effectively, what the lien is, it's just similar to a charge. That's all it is. But it does have limitations. The limitation is that it's only an entitlement to be paid to the extent of its indemnity, but it's to be paid ahead of any distributions to beneficiaries. So under trust law, the rights of the trustee to recover its right of indemnity is ahead of any distribution to a beneficiary. So it's similar to what would happen in a corporation. Creditors get paid before shareholders. So we then come to what I think is the interesting bit, and Henry probably thinks is the interesting bit, but it's probably the worst thing that can happen to people. What happens on a liquidation? Well, company remains the trustee. It's under the control of the liquidator. What you will often find, though, is quite often the trust deed, if there is one, will often set out circumstances in which the trust is terminated or the trustee's rights are terminated. And one of those is often an insolvency. Now, what happened several years ago is the Corporations Act recognised that some of these termination provisions would give rise to problems. So they introduced what lawyers call the ipso facto clauses. But putting that to one side, if a trust deed effectively says your right to hold the property as trust is terminated upon your insolvency, it doesn't take the assets out from the control of the trustee. It just changes the way that they're holding them. They would be then holding them under a bare trust, which again, subject to the same rights of indemnity, the same rights of control, and the same obligations that the trustee and the debts incurred by the trust are paid out in priority to the beneficiaries. But what happens and what's created there is a tension and a conflict. Because when the company goes into liquidation, liquidation is a statutory process. It's governed by legislation. It's governed by the Corporations Act and has been developed over 100 years, both in the UK and Australia. But it's developed alongside trust law. And there are times when it conflicts. Now, those times when it conflicts are when you're talking about distributions, effectively the payment of creditors. Both accept that creditors get paid ahead of beneficiaries or shareholders. That's a given. But what the Corporations Act does, the Corporations Act introduces a priority of payments. It does it in a number of ways. It does it in section 433, 556, where certain creditors will be paid in priority. Now, those creditors are employees, and the priority of employees dates back 50, 60 years, where prior to that, the taxation department had a priority, which they gave up, and priority entitlements, so FEG. What nobody likes to talk about is the priorities that's given to the government to recover payments that they make to employees on the happening of an insolvency. Now, under the Corporations Act, in certain circumstances, those creditors are entitled to a priority ahead of every other creditor. That leads to tension, because under the trust law, there's no priority for them. Now, in the case of Amarind, there was a real focus on that priority because the assets that were available included what were called circulating assets. Now, circulating assets provided, they were book debts effectively, provided that employees got paid ahead of anybody else, including secured creditors. Under trust law, the secured creditor would have been paid ahead of the general body of creditors. So ahead of the government ahead of the employees because it didn't matter. So there was a real tension between trust law, which had been around for 200 years, and the Corporations Act and the legislation, which had also been around for about 80 to 100 years. And this had been ongoing for quite a while. There had been decisions in Victoria. There had been decisions in South Australia dating back to 1956. There had been conflicting decisions in New South Wales and Queensland that had been recently introduced in 2013-14. And this is why the High Court was asked to make a determination on this point. And what the High Court was asked to look at was, what is property of the company? Because it's only property of the company that is subject to the Corporations Act. If it's an asset of the trust that doesn't fall within property of the company, it's not governed by the Corporations Act. And what we have here then is three issues that the court was asked to look at. Is the right of redemption property of the company? Is the lien property of the company? What about the assets of the trust? Do they fall within property of the company, or do they fall within assets of the trust? Even the High Court couldn't give a complete answer. And you had three justices on one side saying it worked in one way, and four justices on the other saying it worked in a different way. So this was in 2019. Each side of that equation came to the same conclusion, but through different sources and through different ways. So instead of giving clarity, it was almost recognized this is a really gray area, but we've got to come to some decision. So in that case, you have Bell, Gaigler, Nettle, and Gordon, who decided that the right of exoneration and the lien itself was not a circulating asset. But because the assets that the trust assets that they were held over were a circulating asset, the Corporations Act applied. So effectively you had Bell, Gaigler, Nettle, and Gordon saying, you look at the assets of the trust to determine whether it's property of the company and what that property consists of. Kiefel, Keane, and Edelman went totally the other way and said, no, the right of exoneration and the lien is property of the company, and that's a circulating asset. So that even the High Court couldn't decide. But what they did decide, is, and this was unanimously, that proceeds realized from the trust assets could only be used to satisfy liabilities giving rise to the right of indemnity. And a trustee's right of exoneration could only be applied in satisfaction of the trust liabilities. Effectively, they said the Corporations Act applied, and those trust assets would be distributed in accordance with the priority regime of the Corporations Act. So the question that remains, though, and was never decided by the High Court, was whether you can use trust assets to satisfy non-trust liabilities. So by way of non-trust liabilities, what do I mean by that? Well, when a liquidator is appointed to a company, he has got statutory obligations to complete the liquidation. He's got statutory obligations to report. He has to circulate to creditors. He has to create accounts. He has to get in the assets of the company and distribute them on a pari passu basis amongst the creditors. Certain of that work wouldn't be considered dealing with the assets of the trust. Certain of that work would be dealing with the costs of the liquidation. So the question still remains, and it can be dealt with, and it's easily dealt with. Would the liquidator's costs in dealing solely with deregistering the corporation be entitled to be taken out of the assets of the trust? They're not relating to trust liabilities. They're nothing to do with the trust liabilities. The answer to that is not entitled to do it on that basis. But what always happens is the liquidator applies to the court to be appointed receiver of the trust, and they get through it that way. But that, through the right of indemnity and the lien, is the way that a corporate entity, a liquidator, can access and obtain assets of a trust. First port of call before any distribution to beneficiaries. I'm going to move on now from corporate trustees, where we're dealing with a liquidation, and I'm going to move to bankruptcy. Now, in relation to bankruptcy, as with all legal answers, it's slightly different. Slightly different legislation applies, slightly different issues arise. So often when an individual, because only individuals go bankrupt, the trustee is appointed, and the legislation that applies to that is the Bankruptcy Act, 1966. What the trustee in bankruptcy is often faces, as a general principle, is individuals who have entered into asset protection strategies. Any individual that trades in his own name or their name will often speak to his accountant, speak to his lawyers, and they will introduce asset protection strategies. They will look to use discretionary trusts to separate ownership of assets from the benefit. So assets will be placed into trusts, discretionary trusts, where there's perhaps even the individual himself as appointed trustee, but it's discretionary, just simply to place the asset out of reach of that individual's creditors. Now that's a standard strategy. Nothing wrong with that, provided it's done correctly. So that's the circumstance that we've got. It's faced every day by bankruptcy trustees. Under the Bankruptcy Act, section 1162A, trust assets are not classed as divisible property for being divided up amongst the creditors of the bankrupt. So they fall outside. As a matter of principle, trust assets fall outside the bankruptcy. Now, that's not to say that they can't be recovered, because what happens is, the trustee is appointed, and he, upon his appointment, is given a number of powers. They're investigative powers. He's able to serve Section 77A notice on individuals saying, I want all documents relating to this. He can apply to the court to have individuals examined. He can ask individuals to attend and be examined by him. Whenever a trustee is appointed, he will go on an information gathering exercise. And he does that for a number of reasons. He does that to understand what are the debts of this individual estate. He does that to understand what are the assets of this individual estate. And more importantly, what has gone on in the preceding week, 2 months, 6 months, 12 months, 2 years, 10 years leading up to this bankruptcy. And he does that because he's entitled, and his job is to recover the assets of the bankrupt. And he does that in a number of ways. He will look at what has happened to assets. Has an asset been in the bankrupt's name? And 2 weeks before the bankruptcy, it's been transferred out, transferred into a discretionary trust. Is that transfer, whether it was done 2 weeks before, 2 months before, 2 years before, was that a transfer that was intended to defeat creditors, to put that asset beyond the claim that could be made by the creditors? Was fair value given for that asset? So, for example, if you've got a house and you've transferred it from an individual's name into a trust, did that individual get full value for that? If he did, what's happened to that value? If he didn't, then the trustee will consider that to be a voidable transaction, or an uncommercial transaction, or a transaction to defeat creditors, and he will apply to the court to set it aside. Moving the transaction on a step further, if the house was transferred for value, but actually cash didn't change hands, but a loan was created, so a loan in the trust, that's an asset of the bankrupt. The trustee in bankruptcy will want to have that asset. He's owed a loan. He will apply to the court, and he will liquidate that trust to recover the asset. So the trustee, even when faced by a discretionary trust, has tools in his armory upon which he can set aside, void certain transactions which have arisen by way of asset transfer or asset protection in the period of time leading up to the bankruptcy. Now, that's a fairly standard approach that a trustee will take. There's nothing new there. That's purely an investigation. What assets were there? What assets are there? What's happened to them? And what can I trace? And can I trace into an asset? Am I able to trace into it? But the Bankruptcy Act in and of itself also has specific provisions that have been created, legislated, and intended to bust trusts open. They are referred to colloquially by, I think, probably Henry and the other insolvency practitioners as trust busting. So in 2006, because of the way in which the commercial market was using the discretionary trusts, the government introduced the bankruptcy anti-avoidance legislation, which resulted in amendments to Section 139 of the Bankruptcy Act. Now, 139 of the Bankruptcy Act is a special provision under 4A, where the legislature looks at ways in which a trustee in bankruptcy can open up a trust, open up the assets of a trust, even when it's a discretionary one, where it appears or is clear or can be proven, whichever way however you want to frame it, that steps have been taken to put assets beyond control. Now, there are certain legislative requirements for that to have happened. So these are called the controlled entities sections. The purpose is to enable recoveries where bankrupts have historically, so that's just not recently, that's over a period of time, diverted personal assets or income to an entity that they control, such as a trust. What these sections do is make them available for the benefit of the creditors. What they can do is the trustee in bankruptcy can apply to court under these sections, and he can seek one of two orders. He can seek an order that property is revested in him. So property comes out of the trust and is revested in the trustee for the benefit of creditors. Or he can seek orders for the payment of money. Now, the requirements to establish a claim under Division 4A at a really high level are the bankrupt has supplied personal services to the controlled entity without commensurate remuneration for those services, or he's provided financial contributions to the controlled entity. He's paid money into it regularly. The effect of those services or that funds or the contributions has been that the controlled entity's wealth, net wealth, benefit has increased. So there has to have been a benefit to that controlled entity. Thirdly, when the bankrupt would have to be in control of the trust, and when he was, he received a benefit out of the trust. He received a distribution. And the trust still has an interest in the asset or still holds a benefit. If a trustee can satisfy a court of those four things, then even where there is a discretionary trust, the trustee will be able to get at the assets and recover them for the benefit of creditors. Now, when you look at the actual authorities on Division 4A and Section 139, there aren't many, I've got to say. And there aren't many because it's really quite hard to do and quite hard to prove. But in the rights, there are at least 5 clear authorities of circumstances where such claims arise and such claims have resulted in discretionary trusts being opened up and trustee in bankruptcies being able to access the assets for the benefit of creditors. And that's why they're called the trust busting ones. So I think in summary, and I'm at the end now because there haven't been many questions, which I'm surprised about. There are ways in which trusts can be opened up, where trust assets can be opened up for the benefit of creditors. They're not straightforward, But your experienced insolvency practitioner, your experienced liquidator, your experienced trustee, they are used to dealing with that. They have seen it all, they have heard it all, they know what they're looking for, and they'll be quite happy to take it on. The flip side, if you get your house in order, if you tick your boxes, if you play a straight bat, it's very hard for the liquidator, for the trustee to get beyond and into the assets of the trust. It's only those that are trying to take a funky stand, do something funky, that opens them up. But they can be opened up. That's it, Henry. It was only 40 minutes, 50 minutes. Sorry.
That's all good. I guess for the audience perspective, you mentioned that to keep the house in order.
Yep.
Do you have any tips and tricks for that, or what kind of main criteria? Documentation, obviously, being one. Obviously, we come across trust that when they changing trust, the trustee. There's no right documentation, and the courts, usually when you go through this, when we're being appointed receiver, those documentation are quite important. And being no documentation is always difficult. So
it's
do you
a
have
bit
any
of a
tips
red
and tricks
flag
for
to
them?
no documentation, as far as I'm concerned. If advisors are advising people to make these steps, and they're intending for them to be accepted as being on the level for value, and aren't intended to create some sort of benefit, there is a straightforward transfer, then that would be documented. The value would be paid, or some value would be capable of, one, it would be the correct value. So you'd value the property in the first instance, whatever it was, and you would give consideration for that. Consideration could be a number of things. It might not just be cash. It might be, okay, well, we'll relieve a loan, or we'll carry on trading, or we'll take on this debt that you've owed. So it could transfer like that. But as long as there's value, that's a sensible value for that asset, and it's documented, then trustees and insolvency practitioners will find it very hard to actually look beyond it. What happens often, though, is documents are hidden, documents aren't created. It's done on the fly. It's done hurriedly because a demand has come in, a massive demand that suggests there's an insolvency. So the timing as well is the important step there, Henry. And this is one thing I was taught over in the UK. If it walks like a duck and talks like a duck and acts like a duck, it's probably a duck. And insolvency practitioners know when something, if it smells fishy, if it looks fishy, if it makes no sense apart from one way, it's probably a transaction that is going to get a lot of attention and is going to lead to a lot of questions. What you want to do is to set out a very opaque, a very white, clean skin. This is what's happened. This is why. This is how it was documented. It was done at this time as an answer, as a complete answer before the question's asked. So I think it's documentation, it's timing, and it's having the right explanation. It's not just any explanation, it's having an explanation that stands up to scrutiny for the transaction.
I recently come across a case, from one of the colleagues that I have, is that they've been, the accountants obviously advised the clients to put asset into a trust.
Yeah.
But obviously, like you suggested, a trust can be breached by a bankruptcy trustee and just a liquidator. is this something that they need to look for when they're advising the clients whether or not to put a certain asset into a trust structure, and is that actual beneficiary for doing so?
I think there always is. My wife owns my house. You know, that's just one of those standard things. I think at the time, though, one question that always springs to my mind is not only why you're doing it, but can you do it? So, and you'll know this, Henry. Somebody's put a property into a trust at a time, maybe 2 years ago. First question you ask is, well, what was your financial position 2 years ago? You know, did you have 3 days before you received the demand for $4 million from the corporate entity that has now got a judgment against you for that $4 million? Or did you not even have the trading with that company that's now got the $4 million claim against you? So if your financial position at the time stacks up, then presumably that's what your accountant's saying. And the recommendation is, look, you've got a massive asset here. You're financially solvent. You don't need it in your name. Put it into the trust. Even when it's in the trust, it's still financially solvent, because we can take that out of your financial statements and you're still fine. Now, in those circumstances, any trustee would be struggling. He would have to attack those financial statements and the underlying insolvency of the individual at the time. And that's yet a further limb. So if you've documented it, if you're financially stable at the time, all you're doing is creating hurdles for the trustee to get over. And the legislation is geared in favor of the trustee. The powers, once an individual goes bankrupt or a company goes into liquidation, the powers that the liquidator and the trustee have to be useful and have to be powerful, because he's coming at a blank canvas. So at that point, everything's in favor of the trustee. What you're trying to do is put up the hurdles before, and hurdles is probably the wrong word, but put up the defenses beforehand that are going to stand up to the scrutiny of not only the trustee, but the court. Trustees have seen it all before. The court's seen it all before. There's nothing new that goes up there.
There's a comment from Sue that the financial that you were talking about, showing the solvency, would she assume that have the asset value to the market?
What you, I suppose there's two elements to that question. There's the first element is, if you're looking at the individual's statement of assets and liabilities at the time, does he need that asset to pay down his debts? And the first answer to that should be, if he does need it, you've got a problem transferring it. If he doesn't need it, okay, you've ticked that one hurdle with the financial accounts. The actual transaction isn't a transaction that is designed to defeat creditors. So you've ticked one box. The question then would it be a voidable transaction? That is it uncommercial? Is it a commercial transaction, or is it an unreasonable transaction? Now, that's where the second limb of the question comes in, as to whether you're getting value or not. So if you just simply transfer it out and you don't get a value in, or a commensurate value in, then that really is an uncommercial transaction. It might not be a transaction to defeat creditors, but it's uncommercial. Now, what the bankruptcy legislation does, and I didn't go into this at the time, but it imposes time limits. So uncommercial transactions, the trustee in bankruptcy, if it's for a related party or if it's for a family member, would go back 2 years, would go back 3 years. And if it was earlier than that, even if it was an uncommercial transaction, he doesn't have the power to set it aside. If it was a transaction to defeat creditors, i.e. when he transferred it, he didn't have enough money left over to pay his creditors, then that has a longer time limit. that actually doesn't have a time limit. So I think there's two elements to that question. I don't know whether I explained it very well there.
I think also one of the key elements is that when you set up the structure, for the accountant's perspective, is that when you set up the structure on behalf of your clients, you probably want to set it up correctly in the first place. Explain to the clients that a trust is not necessarily protect you, and how you're supposed to structure your tradings and assets, and the list go on. And most of the time is that when there's an issue arise, like you said, when there's a demand coming to your way, or you aware there's a demand, the fact that you're weighing of it and then you do the transfer, it causes issues. So it doesn't matter how, you have to have more document than when you set up the structure correctly, basically. Try to defend those transactions.
There's always a timing element, and there's always a story.
Correct.
Whatever case I've been involved in, there's always been a story. They're always quite interesting. They always follow the same path, but there's always a story. Yeah,
and I think important, for the accountants in the group is that there is powers for liquidators and trustee to breach a trust structure. Yep. Putting asset into the trust, not necessarily protecting your client's interests. And when you're advising them on a certain path, it's something that need to be mindful of. Because for example, if the guys can be resolving a liability without going bankruptcy, maybe should be avoiding that bankruptcy if there's a massive house into the trust, and he's the beneficiary of that trust, for example. And that's something that need to be considered, when you're advising the clients on a structured basis.
I think that's right, Henry. I think it's the same with any of these matters. If you've got a concern, if you've got an itch that you need to scratch, I think the sooner you take professional advice, professional insolvency advice, speak to an insolvency practitioner like Henry, like the other practitioners on here, they can probably help at that stage. And that in my experience, what happens is people talk to insolvency practitioners when it's too late. The horse is already bolted. There's nothing left to save, or what was left to save has gone. But if you can speak to them early enough, there are methods and ways in which they can actually take steps to preserve a business, preserve assets, create a structure that actually works, that gets you out of it. But they have to be spoken to early enough and quick enough to give them something to save. That's my take. So I'd probably banging the drum for insolvency practitioners, which is probably good timing, but the sooner you can speak to them, the better, because they're all experienced in it. They've seen it all before, and they know exactly what they're going to look for, and they can just take your hand and walk you down a path that'll often lead to a better result than might happen with if you don't take their advice.
All right, Teddy. Is there anyone have any other questions?
I can't see anyone asking question there.
Yeah, no, that's no hand been raised as well. So cool. All right.
Very cool. All right.
Thanks
So
for the opportunity, guys.
That's it.
Okay.
So on behalf
you want to do the closing?
Yeah. On behalf of the CP Australia City Taxation Discussion Group, Henry and I would like to thank you, Richard, for your contribution, for your time, your effort this afternoon. If any one of you have any further question, you can contact Richard directly. He's got his detail on the screen there, or anything to do with insolvency, you can contact Henry, I suppose. Get an early advice, as Richard mentioned earlier, is very important. So thank you all once again for attending tonight's session. And as this is our last session for this year, we hope to see everyone back again next year in February. And we are looking forward to welcome more members back in CBA venue next year. And also thank you all for your support throughout the year. And we appreciate all your support and also all your attendance throughout the year. And so until then, we wish you a very Merry Christmas and a happy and safe New Year. Thanks, everyone.